No response, Your Honor.
All right, his bond will be forfeit non-appearance and reset at $100,000. He did call, say he was having issues. If he gets here late, then I'll obviously recall that bond forfeiture.
Okay. And Judge, like I
You've
said,
got Karis and, oh, go ahead, I'm sorry.
he did call this morning. When I tried to call him back to his house number, he was already gone, so I'm assuming he is trying to...
Maybe on his way. Okay, thank you. And then you've got Karis Antoine, Mr. Lewis.
Yes, ma'am, Judge.
Are we? Okay. You're Karis Antoine, and this is cause number 24 DCCR 1878. It looked like I did sign an order back in May for CPS records.
You did, Judge, and we contacted them this past week asking for an update. They hadn't gotten back with us yet.
Okay.
I even had Mr. Hoppower call because he's used to dealing with them.
Right.
And he did that for me at the end of the...
Right out of the gate, the judge sends a powerful message. Showing up to court isn't optional. She forfeits the bond immediately. But notice the balance. She also says she'll reverse it if the defendant arrives today. That's accountability with a chance to make things right. Would you call that tough but fair, or should judges be even stricter?
And that's about it.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can. Sometimes that helps to get things moved along.
So reiterate what said. I spoke to them by email.
Okay.
But we still haven't received those records.
And she didn't give any update on when we could expect them?
But it was Friday.
Okay.
I got contact.
She's usually pretty responsive.
Yes.
All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully, if we get that before the next court date.
Thank you, Your Honor.
Thank you.
And off the record, I'll show you their email reply to Mr. Hoppower's voicemail. Sound about right?
He's giving you a hard time without saying anything.
I know, I understand. It's okay.
You can handle it.
Next game.
This is one of those courtroom moments most people never see. Cases don't always stall because of lawyers or judges. Sometimes they're waiting on outside agencies to send records. It may seem boring, but these delays can decide how quickly justice moves. Have you ever waited on paperwork that held everything up?
Mr. Rojas, you've got Carnell Beard. Good morning, Mr. Rojas.
Good morning, Your Honor.
Good morning, sir. Are you Carnell Beard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He would, Your Honor.
Are we going on count one? Oh, no?
No, ma'am.
Okay.
Everything.
Okay, let me, all right, and he'll waive the formal reading of the indictment.
He will, Your Honor.
Mr. Beard, you're charged with the third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999. And after that was final, you were convicted of possession of a controlled substance, a first-degree felony. Well,
Judge,
do we just need to go on one, or
Let's
is
just
that?
go on one, because I'm looking at the dates, and they do overlap, so it would not make them
It
habitual.
wouldn't, so it makes it a second-degree felony.
Your Honor.
So what that,
Hey race, a legal concept that changes everything. Punishment enhancement. The current charge stays the same, but prior felony convictions can dramatically increase the possible sentence. In court history doesn't disappear. It follows you. One decision years ago can completely reshape what's at stake today.
nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case. We'll also get that restitution amount determined, and then we'll come back later for sentencing. When you're on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see you back at sentencing.
Thank you, Your Honor.
And then you've got Zachary Turner.
Notice the judge doesn't rush straight to sentencing. Instead, she orders a pre-sentence report to learn more about the defendant's background, circumstances, and restitution. That's a reminder that sentencing isn't just about the crime. It's also about gathering the information needed to reach an informed decision.
Turner, Mr. Rojas. Good morning, sir. Are you Zachary Turner?
Yes, ma'am.
And this is 24 DCCR 2197. And Mr. Turner, you're charged by indictment in this case with the first-degree felony offense of fraudulent use or possession of identifying information from April 22nd of 2024. Your indictment alleges that you were previously convicted of unlawful possession of a firearm by a felon, a third-degree felony, September 29th of 2014, which means that this, for punishment purposes, would be enhanced,
15
but
and 99 is the way we.
This is the turning point of the hearing. By rejecting a 15-year plea deal, the defendant is taking a huge legal risk because the state says it may pursue habitual offender enhancement. If that happens and he's later convicted, the sentencing range could become far more severe. What would you do? Take the deal or fight your case at trial?
Indicted, Judge.
right.
Given the rejection of the state's offer today, I believe we can make him a habitual, and I will be filing a habitual offender notice in this case.
So, and you've gone over that with Mr. Rojas, correct? And so I want to make sure you understand that if the state files that notice of enhancement with another prior offense, which I would assume you have since the one I see is an unlawful possession of a firearm by a felon, that means that if you go to trial and you're found guilty.
And that's the final warning. Once a case moves onto the trial docket, the original plea offer may no longer be available. Decisions made in a courtroom often have lasting consequences, and timing can matter just as much as strategy sometimes. The biggest gamble isn't what happens at trial, it's the choice made before the trial even begins.